speaker is Ms. Yu Katie Lam. She'll be talking about the role of the law of unjust enrichment in Malaysia. And Ms. Hang is one of our students. She's on our Juris Doctor program, and she's just coming to the very end of it. So she's just coming to the end of her studies now. She completed her undergraduate studies at the University of Rochester in the United States, where she was awarded the William Morse Hastings Prize for a dissertation on China's happiness paradox. Katie has also deepened her understanding of various aspects of international laws through working at the European Union, where she was involved in researching on energy and transportation policies. Katie's research interests lie in the areas of financial regulation, international taxation, and equity and trusts. The final one, of course, being the most important. A developing interest for her and the subject of the paper at this conference is the Malaysian jurisprudence in the law of unjust enrichment, with a focus on whether there exists a coherent framework between the statutory regime and the common law principles in Malaysia. In amongst all this, Katie also works in a multinational hospitality group and oversees compliance measures as well. So, Katie, hopefully I've just seen you in a separate room in the faculty, so it's over to you. You can upload your slides. Thank you, Katie.
Sure. Thank you, Professor Gallagher. And thank you for having me here today. And let me share my screen first. Yeah. I would like to take this chance to thank Professor Wood for his support throughout, and Professor Gallagher, Bonnie, and other ME staff to make this exciting conference happen. And there's a lot of insightful discussion this afternoon. So I very enjoyed every of it. So today's objective is to go over the role of unjust enrichment in Malaysia. And basically Malaysia's unjust enrichment law is multifaceted in nature. It is governed by the statute regime and the common law. So my research is to identify the correct theoretical basis of what is the law that is actually rooted in to formulate the statutory regime, because these facts have often been overlooked. And the second part, we'll go over the statute and then the common law, and then we will go over the next step. What is the next step to develop this area of law? So first, it is important to look at the history. I would like to start with the quote from Sir John Inglis, saying that the importance of developing a jurisprudence is to look at the roots of the law, and in order to develop it coherently. So, and because we cannot ignore the history, the culture, and the background of how the law formulated. So a brief history is that, and it's very difficult to reconcile all the Malaysian decisions involving the law of restitution and unjust enrichment prior to 1974 due to different systems implemented at different times. As you can look at the map, there are different color coded, and you see in highlighted in blue, there's the Contract Malay State Ordinance 1950 was made applicable to all the highlighted in blue unfederated Malay states. And the Contract Malay State Ordinance 1950 is actually will become the Contract Act 1950 that is the statutory regime for the law of restitution and the law of unjust enrichment. The timeline of the law of unjust enrichment is that the first is the Indian Contract Act is enacted in 1872, and the Malaysian Contract Act is enacted in 1950. And the reason I mentioned about the Indian Contract Act is that the Malaysian Contract Act is modeled upon this Indian Contract Act, and basically it is based on the UK law, but there's a few exceptions that we will look at later. And the common law of unjust enrichment is declared in the seminal case in Lepkin, Gorman, and Cornell Limited. And common law of unjust enrichment in Malaysia is established in Dream Property in 2015. The Contract Act, as I mentioned, is modeled upon the Indian Contract Act 1872 and is mostly a codification of the English law, except for the restitutionary provisions. But this fact has often been overlooked, and this affects how the practitioners and how the judges interpret the ordinance. That will affect the scope of remedy and what kind of occasion that the remedy can be offered to the claimant. So the reasons for the departure from the English law of these restitutionary provisions can be categorized in three forms. The first one is because of the state of English law in 1867, which is the year that the Indian Contract Bill was drafted and is influenced by the drafters' view on the differences between the law in England and in elsewhere. So they look to the Roman law for references. Because of the chaotic state prior to the enactment of the Judicature Acts, before that, common law and the rule of equity are divided, and that lead to a lot of legal uncertainty. Basically, different legal outcomes will be happening based on the same facts. And also the technicality underlying in the English law of unjust enrichment. In attempting to develop this branch of law, there are a few attempts such as doctrine of assumption, the implied contract theory, and the act of money had and received. So that these some of them have been abandoned because of the technicality and over complexities of this area. And the restitution based on Roman law have been awarded in wider range of cases, such as in partial failure of consideration, volunteer, frustration, and impossibility of performance. All these scenarios are unlikely to be awarded for recovery in English law because of different culture backgrounds. So for Roman law, it promotes the volunteering policy and altruistic policy to encourage others to and help out each other. But for English law, there's more a sense of autonomy that is unlikely that people will get awarded unless in some special circumstances. So for the statutory interpretation is that the first starting point is to interpret the provision as they stand with the aid of the illustration contained in the legislations. Basically in the Contract Act 1950, there's a few illustrations in each provisions. And these illustrations demonstrate in some scenario of whether the recovery is possible. And from studying all these illustrations can help us to understand whether in this scenario and is wide scope of scenario that maybe whether the remedy is possible. And secondly, the Malaysian court is bound by the decisions of the Privy Council in respect of appeals from Malaysia or India in the interpretation of the Contract Act 1950 or the Indian Contract Act. However, also, Malaysian courts offers flexibility in considering whether to follow the English law in other area of law. There's a Civil Acts Section 3 and 5, basically saying that English law, the general exception of English law in Malaysia. However, in some special circumstances, and when we consider the local conditions, Malaysian law can have some flexibility in considering whether to follow English interpretation or not. So the statutory overview of the restitutionary provisions can be categorized in 3 Roman law principles, which are because of in the interest of time and the volumes of the Roman law, there's basically the conclusion is the Roman law offers a wider scope of remedy to compared to English law, and it is very interesting to see that. And there the Privy Council has already interpreted and recognized the Roman roots of the Contract Acts as 65 to 66 is based on the conditioners, and all these conditioners is the circumstances allowed the recovery to happen, and for 69 to 72 is exemplify this negotiator gestual principle, which is about resemble fiduciary duties in English law. And for section 73 is more resemble in the mistaken a mistake of law and mistake of fact recovery. And Roman law offers a wider scope of recovery in the sense that it doesn't distinguish between mistake of fact or mistake of law, but in English law is actually differentiate, and the remedy is limited in this sense. So yeah, as stated as section 66 is a right to restitution may arise out of the failure of contract, though the right be not itself a matter of contractual obligations. So, and this, and the section 71 is a right to restitution for non-gracious act lawfully done for the benefit of another person. And is in the case of like the mistaken improver of land that we will later on look at in the dream property case. There's actually a debate about whether when to use section 71 in the statute or when to use common law after dream property granting the judicial blessing of common law of unjust enrichment. And to complete, the section 73 is a right to restitution in cases where there has been payment of money or delivery of a thing which was not legally due and which could not have been enforced but was paid or delivered by mistake or under coercion. And the language of not legally due is resemble Roman law, and that 73 is the cornerstone of the principle of unjust enrichment based on the Roman scholars in the sixth centuries. So now we come to common law dream property Atlas housing case, and this is the case about the mistaken improver of land. So this is the case where the fact is that the seller, Atlas Housing agreed to sell a piece of land to Dream Property for a price of RM 33.5 million. So with an aim to develop the land into a shopping mall, the contract provided that the purchaser, which is Dream Property, was entitled to commence the construction work on the land prior to the completion of sale. And the seller also granted the purchaser Dream Property a POA to deal with the land, and to continue to build the mall. And after paying the required deposit, a dispute arose between the parties because the balance of the contract price wasn't paid on time. So the seller commenced a legal proceeding to have vacant possession of the land of the land. However, the seller didn't only send a letter to the purchaser without further actions. So this is the point that was raised by the court later on, saying that the seller didn't do enough work to evoke the POA, so the construction of the mall is legal in itself. And then the issue of one of the issue of this case is whether the purchaser as a contract breaker is entitled to recover from pursuant to the doctrine of unjust enrichment. And second, what is the proper measure of the restitution, whether it's the cost of land, cost of construction, or the market value of the mall. Of course, the purchaser during property would like to recover the market value, which is tenfold of the cost of land. And in Court of Appeal, the remedy was awarded cost of constructions, and this is when the case come to federal court, which is the apex court, and they have other consideration as well. Yeah, so this is the issues that I've mentioned, whether a contract breaker is entitled to restitutions, and what is the proper measure if the contract breaker is entitled to restitutions. So the purchaser's right of, regarding the first issue, the purchaser's right of recovery was premised on the law of unjust enrichment, which is of restitution, not compensation in nature. And by saying restitution in nature, it means that the recovery of a benefit that is unjustly gained by a defendant at the expense of the claimant. And then compensation is loss-based, and loss-based in the sense that the loss will need to be compensated. The loss of the contract break, the loss of the other party will need to be compensated. And in this judgment, federal court has been quoting extensively in the English law, and quote extensively in the seminal cases, survey the Goff and Jones on law of unjust enrichment, and the court opined that the recovery should be restitution on the basis, and therefore the purchaser during property is entitled to restitution pursuant to the doctrine of unjust enrichment under the common law. The second issue is the measurements of the remedy if there's a case on unjust enrichment. And in some, the court approved the 4-stage inquiry, which is was the seller enriched, whether the enrichment is at the expense of the purchaser, or was the enrichment unjust, and whether there's any defense available. So the issue of defense wasn't raised in this case. And what about the ground breaking aspect of this case law is that the federal court surprisingly and boldly adopts the absence of basis approach in the third inquiry. So the absence of basis approach is whether the enrichment is unjust, if there's any legal basis or cause for the defendant to retain the enrichment in questions. So arguably this is like a shift of perspective to see whether you're able to keep the unjust enrichment if you can prove this is not unjust. And under the unjust factor approach, it is the plaintiff will need to prove positively there's an factor for the recovery to be rewarded. So we quickly go over the whether the analysis is that the court, for the first inquiry, the courts opined that the seller was enriched because before that it was only a land, and now there's a land with a mall that with enhanced value, tenfold of the value. So this requirement is pretty straightforward and easily satisfied. And the second one is whether the enrichment is at the expense of the purchaser. For this one, the court said that the purchaser had expended significant time, effort, expertise, and all its own costs in establishing and maintaining the mall to the status and success it had reached to date. And through the soul and acts and effort of the purchaser, the value of the land has increased. So yes, this requirement is satisfied, and the court proceeds to move on to the third issue, is whether the enrichment is unjust. And in this case, the court saying that yes, it is unjust. And the reason that they adopt the absence of basis approach is that they think that is offered a fairer outcome than the unjust factor approach. And this inquiry has incited a lot of academic debates on whether going forward we need to develop the law on the basis of absence of basis approach or unjust factor approach. And at the formative stage of the law, a lot of scholars sided with the unjust factor approach, even though the federal court has already said that absence of basis approach is the next direction in the law. And the criticism of this case is this approach is oversimplified, and it doesn't provide like a rigorous approach like in that we can see in the common law. And the absence of basis approach, the court didn't give much explanation of why absence of basis approach is adopted, besides only saying that it's offer a fairer outcome. So, and there's a big gap between the substance and what kind of basis would constitute the unjust, and what is the substance in this approach. And the word is the court rewarded the market value of the mall to the purchaser during property, which is 387 million, because it said it thinks that it would be manifestly unjust and unfair to the purchaser if the seller can benefit from a full operational mall without paying the whole value. And this inquiry actually have received a lot of criticism because from UK law, the court cases that actually will side with the cost of construction, which is RM 124 million, and this will actually be unfair to the seller. Unfair to the seller because because it said that he needs to pay like a substantial amount more than the cost of the construction, and actually the seller may not want to have the land to develop as a mall. They may want to have the land to develop as maybe like a residential area. So for lowering the threshold of the defense of unconscionability in the English law, basically this is the scholars are arguing against this approach and advocating for the cost of construction, which is cost of the labor. And I think this is a fair take because as a like a mistaken improver of land, there is in this case we are we are imposing a lot of burden to the seller, and just because he didn't invoke the POA or didn't do more to revoke to communicate the proceedings wise, it doesn't make him liable to pay the extra amount of money. And the observation on the post-Green property case is that now we are 5 years after the Green property case, and there's a lot of the three sense of cases about the cases after Green property is that the absence of basis approach is still not fairly developed. For instance, in this case, the court simply say absence of basis principle is adopted, but without elaborating on the absence of basis, what kind of basis. It's only with one sentence saying, oh, this is absence of basis. So we found an absence of cases, and this is kind of circular in a sense.
Eddie, can you just draw it to an end there, because I think we need to get on to the next speaker.
Okay, yeah. So the future development is to identify the Roman law as the theoretical basis of the restitution provisions in the statutory regime, and to develop coherently regarding to the historical legal origin. Yeah, and the proposed approach is to consider whether the facts of the case give rise to the unjust enrichment is already covered in the Contract Act first, and then we will develop a more coherent framework and then enable a consistent application of the law in the future. Thank you.
Thank you, Katie. That's an interesting consideration of Malaysia. A very strange way it's developed there in Malaysia.